12 strangers enter a courtroom. They will never see the crime. They will never step inside the victim's last moments. All they'll know is what the lawyers show them, what the judge allows, and what the evidence suggests. Yet when the door closes, those 12 strangers must make a decision that will echo for the rest of someone's life. Tonight, we step inside the jury room, where doubt, persuasion, and human psychology shape justice. Who are the 12? Before the first piece of evidence is heard, the justice system chooses who gets to hear it. Voir dire, jury selection, isn't just about finding 12 citizens. It's an adversarial process where prosecutors and defense attorneys try to sculpt the most receptive audience for their story. Some jurors arrive believing in the system's reliability. Others arrive wary of police, of prosecutors, of experts. Some have never been in a courtroom. Some have watched every true crime documentary ever made. Many hold quiet assumptions about guilt and innocence. They don't always know they hold them. Lawyers look for the edges. A juror who says they trust science might be great for the state in a DNA-heavy case, but a nightmare if the defense is fighting a weak lab result. A juror who distrusts police may be open to a coercion narrative in a confession case. The goal isn't to pick a perfect jury. It's to pick a jury that might see the case your way. And there's the judge, the referee of what the jury gets to hear. In the background, rulings on evidence, what comes in, what stays out, quietly decide the case before it begins. First impressions, the frame of the story. Trials are stories told under rules. Opening statements set the frame. The prosecution goes first, an advantage most jurors don't recognize. Hearing one side's roadmap before the other creates primacy. The facts that come later are judged against the first narrative they heard. A strong opening doesn't just list witnesses. It gives jurors a reason to care and a structure to put all future evidence inside. You will see a timeline. You'll hear a neighbor. You'll watch a video. The defense must then either build an alternate story, or punch holes in the one that's been laid out. Inside the jury room, first impressions are stubborn things. If juror number 4 believes the first story fits, later facts feel like confirmations. If juror number 9 felt the first story overpromised, later inconsistencies glow brighter. In psychology, we call it anchoring. Early information weighs more than it should. In court, anchoring can become a verdict. The evidence jurors trust, and why. Evidence is not equal in the minds of jurors. Some forms feel authoritative, others feel slippery. Here's how jurors tend to sort it, rightly or wrongly. 1. DNA and forensics. Jurors often treat DNA as the gold standard. A profile match with astronomical odds can overpower nearly everything else. But as we've explored on Silent Veil, DNA is powerful and fallible. Contamination, mixed samples, and misinterpretation can seed doubt. When prosecutors present DNA clearly, what it proves, what it doesn't, jurors lean toward confidence. When defense attorneys expose chain of custody gaps or probabilistic gray zones, jurors lean toward caution. 2. Digital footprints. Phone pings, GPS logs, surveillance video, purchase records, these feel objective. A timestamp and a map pin are hard to argue with. Still, jurors can be swayed by defense arguments about tower range, spoofing, or misattribution. Was the defendant holding the phone? Was the account truly theirs? The more the state stacks independent digital points that agree, the more persuasive it becomes. 3. Eyewitness testimony. It's vivid, human, emotional. It's also fragile. Lighting, distance, stress, weapon focus, small details change memory. Jurors often want to believe eyewitnesses because it feels close to the moment. Good defense cross-examination reframes eyewitness confidence as fallible, not malicious. 4. Confessions. Jurors instinctively think, why would someone confess if they didn't do it? But modern cases show false confessions happen, under pressure, threats, exhaustion, or misunderstanding. Jurors become cautious when they hear about long interrogations, vulnerable suspects, or promises that muddle voluntariness. The judge's instructions on voluntariness matter. So does the recording. Video of the entire interrogation can make or break whether the jury trusts what it hears. 5. Expert witnesses. Experts can clarify or confuse. Jurors like plain language and demonstrations. They dislike jargon and over-claiming. Two battling experts can cancel each other out, unless one uses visuals to teach, not preach. 6. Character and motive. Motive helps jurors understand why, but it doesn't prove who. Character evidence is tightly controlled because of how powerfully it can mislead. Jurors often think a good person wouldn't do this. The law reminds them, good and bad are not evidence. Actions are. In the end, jurors trust what feels consistent. Evidence that fits together, across time, place, and witness, builds belief. Evidence that clashes creates doubt. How lawyers shape perception. Courtroom persuasion isn't just facts, it's format. The same piece of evidence can feel stronger or weaker depending on how it's presented. Timelines and maps. Humans are storytellers. When lawyers place events on a clear timeline or map, jurors can see cause and effect. If the defense can drop just one stubborn point that doesn't fit, 1 minute unaccounted for, one ping that contradicts, jurors start to question the entire structure. Demonstrative exhibits. Charts, diagrams, 3D models, transcripts with highlights, visuals that teach are sticky. Jurors remember images even when testimony blurs. But if visuals exaggerate or oversimplify, a sharp cross-examination can expose the trick and damage credibility. Language and framing. He ran from the scene versus he left the scene. She admitted versus she acknowledged. Microframing steers emotion. Jurors feel the difference even if they can't name it. Careful judges instruct jurors to focus on evidence, but language sneaks under the door. Cross-examination as theater. The best cross isn't aggressive, it's surgical. Short questions. Yes/no answers. One fact at a time. The goal isn't to humiliate, it's to plant a doubt the jury can't pull out. The moment a witness hesitates on something they were certain about, jurors feel the floor shift. Inside deliberations, the foreperson, the holdout, and the clock. When the door closes, a new trial begins, without the judge. Without the lawyers. Just the 12, a verdict sheet, and instructions. The foreperson. Sometimes chosen by a vote. Sometimes the loudest voice claims it. A good foreperson keeps order, encourages quieter jurors to speak, and walks the group through each charge. A bad one can railroad the room. The first vote. Many juries take an early straw poll. It's a weather report, not a verdict. But early tallies can anchor positions. If the room starts 10-2, the two feel pressure. If the room starts 6-6, the mood is cautious and open. The holdout. There's almost always one. The holdout isn't stubborn by default, sometimes they're the only person who wrote down a key inconsistency or circled an instruction. Other times, the holdout is reacting to emotion, not evidence. The group must sort which it is, calmly. Pressure can cross the line into coercion if jurors feel bullied. Time pressure. Deliberations take as long as they take. But jurors are human. They have jobs, kids, exhaustion. A long day can make a compromise verdict tempting. That's why judges remind them, speed is not the goal, accuracy is. Reading the instructions. Legal language is dense. Good juries reread the instructions together, out loud, tying each piece of evidence to the actual elements they must decide. Beyond a reasonable doubt isn't beyond any doubt. Intent isn't bad person. Words matter. Requesting readbacks and exhibits. Juries can ask to rehear testimony or see exhibits again. The sections they request often reveal the fault lines, time gaps, contradictory statements, a technical expert's key assumption. In this quiet, the case is decided, not by who shouted loudest in court, but by which story holds its shape when the door is shut. Biases that sneak in. Jurors swear to be fair. Most take that oath seriously. But human minds come with shortcuts that don't turn off at the courthouse door. Confirmation bias. Once we lean one way, we notice facts that support our lean and ignore what doesn't. Good juries fight this on purpose, by asking the strongest questions against their own position. Hindsight bias. When you know the ending, the path to it looks obvious. Jurors must ask, what would this evidence have looked like before we knew what happened? Anchoring and primacy. First stories weigh more. To counter it, forepersons sometimes start deliberations with the defense's strongest points, forcing the room to reckon with doubt first. Groupthink and conformity. It's uncomfortable to be the only dissent. Healthy juries protect space for disagreement early, so later votes mean more. The CSI effect. Expecting perfect scientific proof in every case can be as dangerous as trusting junk science. The instruction is simple: judge the evidence you have, not the TV version you wish you had. The story model. Jurors don't add up facts like a calculator, they build a story that explains them. The winning side usually isn't the side with more facts, it's the side with a story that fits all of them without tearing. When evidence collides. Real cases present contradictions. Here's how juries wrestle with three common clashes. DNA versus alibi. If a clean DNA match places the defendant at the scene, but a friend swears the defendant was with them, most jurors lean DNA, unless the defense shows a plausible path for transfer or lab error, and the alibi witness is unimpeachable. Even then, it's uphill. A single forensic piece can outweigh multiple human memories. Timeline versus character. The state presents a tight timeline. The defense shows the defendant is a gentle parent, a steady employee, a volunteer. Jurors must set character aside. Good people commit crimes, bad people sometimes don't. The element isn't, is the defendant nice? It's, did the defendant commit the charged act beyond a reasonable doubt? Experts versus experts. When both sides bring scientists, jurors default to clarity. The expert who teaches wins. Visuals win. Humility wins. Here's what this data can tell us, here's what it can't, sounds more credible than absolute certainty. The judge's voice, burdens, elements, and doubt. In the end, jurors must translate evidence into law. The judge's instructions are the bridge. Burden of proof. The prosecution carries it, always. The defense doesn't have to prove innocence. If the evidence leaves the jury firmly convinced, that often satisfies the standard. If a reasonable doubt remains, one based on reason and evidence, not speculation, they must acquit. Elements of the crime. Each charge is a recipe. Miss one ingredient, intent, identity, causation, and the verdict can't be guilty on that count. Organized juries take the elements one by one, voting on each silently before turning to the next. Lesser included offenses. Sometimes the law offers rungs on the ladder: if not murder, then manslaughter; if not aggravated, then simple. That structure can prevent all-or-nothing deadlocks. Unanimity. In most serious U.S. criminal cases, verdicts must be unanimous. A single juror can hold the line if they believe doubt remains. That's not a bug, it's a feature designed to protect liberty. Hung juries, pleas, and the shadow of retrial. Not all deliberations end with a verdict. A hung jury, when unanimity can't be reached, means mistrial. The state may retry the case. Or it may offer a plea. Or it may walk away if the evidence looks weaker the second time. Jurors sometimes feel they failed when they hang. They didn't. Their duty isn't to finish, it's to be honest. If the evidence doesn't cross the line for every person in that room, the system says, stop here. A composite jury room, the flashlight and the footprints. Let's walk through a hypothetical, built from patterns we see in real trials. A store is robbed at night. The clerk says the robber wore a dark hoodie and had a distinctive limp. Police arrest a suspect 2 days later. The case goes to trial. The state's story. A neighbor's camera shows a figure jogging away at 11:07 p.m. The defendant's phone pinged near the store at 11:03. A partial shoe print behind the counter matches a style the defendant owns. In the defendant's closet, police found a hoodie with a torn cuff. The clerk ID'd the defendant in a photo array. The defense story. The defendant says they were out walking to clear their head, which explains the phone ping. The shoe style is common. The hoodie was torn weeks ago. The clerk admitted the robber wore a mask. The camera footage is grainy. The defendant does not limp. There's no DNA, no fingerprints, no cash recovered. Inside the jury room. They start with a straw poll, 7 guilty, 5 not sure. The foreperson suggests they list the elements: identity, intent to steal, force or fear. They examine the phone ping. Range could be half a mile. One juror notes, the ping time and the video time are close. Another counters, close isn't proof. They re-watch the camera clip. It's dark. The figure's gait is debated. Do they see a limp or just a bounce? Jurors disagree. They study the shoe print. The style match feels weak. No unique wear pattern. No size certainty. They discuss the clerk's ID. High stress, short view, a mask, a weapon nearby, factors that harm accuracy. One juror is uncomfortable relying on it. They ask for a readback of the detective's testimony about the photo array. Were fillers similar? Was anything suggestive? The readback shows the lineup was fair. That calms some concern, but not all. Hours pass. The group is 8-4. Then 9-3. The holdouts keep pointing to the limp versus no limp. A juror suggests, if the person had a limp and our defendant doesn't, that's a reasonable doubt unless there's an explanation. Another juror says the clerk could have been wrong about that detail. They reread the reasonable doubt instruction. It doesn't mean imaginary doubt. It means a doubt grounded in reason after careful consideration of the evidence. The foreperson asks each holdout to name a single piece of evidence that, if stronger, would change their mind. 2 say, DNA or fingerprints placing the defendant behind the counter. 1 says, a clearer video. By nightfall, the jury is 10-2 for not guilty. The 2 for guilty are anchored by the phone ping and the timing. The foreperson proposes, revisit each element. On identity, they cannot reach unanimity. The judge declares a mistrial. In the hallway, some jurors feel unresolved. Others feel proud they resisted pressure. Inside the prosecutor's office, a question: is the case strong enough to try again? Inside the defense office, if we retry, do we find the missing piece? The system moves on. In the courtroom, justice isn't a machine, it's a conversation. Between law and evidence, between logic and memory, between what happened and what can be proven to have happened. Jurors carry the heaviest weight. They bring their hopes, doubts, and humanity to a table and try to see clearly through the fog. They don't just decide cases. They define what reasonable means, today, in this community. For the rest of us, the lesson is simple: demand clarity. Build stories that fit facts, not the other way around. Respect the standard that protects us all, beyond a reasonable doubt. This is Silent Veil. We lift the veil on hidden stories, always with respect, always with truth. Subscribe for cinematic true crime every Tuesday and Friday.